The trigger trust is an asset protection trust that contains the most favorable components of the domestic asset protection trust with the tremendous strength and track record of the foreign asset protection trust. And it's much easier to operate than the traditional domestic asset protection trust because the settlor, which if you're setting up the trust, that would be you, is often the initial trustee. The trust also has an offshore trustee, which is our offshore law firm. Our offshore law firm / trustee can elect to pull the trigger to erect the armor plating of the foreign asset protection trust. Hi, I'm the business guy, and I've been the CEO of an asset protection firm for over 30 years. We have attorneys on staff, and if you need further help, please give us a call. And if you could do me a favor and please click the like button below, it would help me a lot for the YouTube algorithm, so more people like you can see this video. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. The Trigger Trust is a certified and registered asset protection trust from day one. The trust has an international registration certificate. The verbiage is already in place to enact the powerful Offshore Asset Protection Trust verbiage. The client supplies the legally required due diligence to meet the Know Your Client regulations. The foreign trustee is in place up front and plays a passive role initially. So once the legal threat arises, it only takes a matter of moments for the protector or trustee to engage the legal weaponry of the offshore trust. Doing so does two things. One, it removes the U.S. trustee, and two, it removes the verbiage that the trust is under control of the U.S. courts, because leaving that verbiage in the trust would leave assets at risk, and removing that wording and moving assets to a safe offshore location helps ensure their safety. By the way, our organization holds the federally registered trademark on the Trigger Trust, and we are the only ones who can legally set up this kind of trust and call it a Trigger Trust. The problem with domestic trusts. There's one big problem with domestic trusts. They often don't work. Many times we have seen results-oriented judges penetrate domestic trusts, and this is especially evident when you study case law history and you see, for example, a California resident using a Nevada trust. The judge says, in effect, great, you have this trust, but you are here, the assets are here, and I'm going to seize them. This result is not limited to California. In Dahl versus Dahl, Dr. Dahl filed for divorce from his wife in Utah. He had established a Nevada trust, and Dr. Dahl was a settlor. The appeals court ruled that the wife had the right to revoke the trust. Since the couple lived in Utah, which does not currently have domestic asset protection trust statutes, the judge ruled that Utah state law applied. In order to enjoy time-tested protection, the trust and its assets must be beyond the reach of the local courts. And that is why when legal duress strikes, it is prudent to pull the trigger and enact the offshore trust protection. You or your trustee then move the funds to a safe international institution in a jurisdiction that does not enforce U.S. judgments. We employ equity stripping measures on real estate to remove the equity from the real estate and move the proceeds offshore. Tax matters. For those with a technical knowledge of the tax aspects of asset protection trusts, this section is for you. If it is a U.S. client establishing the structure, the trust is initially a U.S. trust for tax purposes. It will have a domestic trustee, often the client. It will initially be under U.S. court control, and as such, there is no need to file the foreign trust tax forms. As an aside, these forms, 3520, 3520A, and FBAR forms, are quite simple and straightforward if the protector or trustee enacts the foreign asset protection trust option. Now, at the initial state, before triggering, there is no need to file a separate tax form or get a separate tax ID number. The trust simply uses the Social Security number of the client. The IRS considers it a domestic grantor trust. Now let's address the word trigger. The IRS does not recognize a trust as a domestic trust if there is an automatic triggering mechanism that converts it into a foreign trust. So the trigger is not automatic. The conversion requires human intervention. That human intervention usually means you telling the trustee or protector that you have encountered legal duress. Once so informed, the trustee/protector will take measures to enact the offshore trigger. Simplicity. Because of the simplicity of this trust, It is as easy to use as a living trust. It is easy to open a bank account in the name of the trust, and we also usually make arrangements so that the trust owns 100% of an LLC. So even if the legal waters get rough enough for the foreign trustee to step in and protect you, you have a vehicle inside the trust that you can use to operate your business and investments. You also have a bank account in the name of the company, coupled with a couple $1,000s initially, so you have an open baseball glove to throw the ball into someday if you need it. You immediately wire funds into that waiting account. Then, once you are convinced that you are losing a legal battle, you can likewise have your trustee step in to take the protective measures of a trust-owned company. The trustee initially is a licensed bonded attorney group based in the Cook Islands south of Hawaii. The Cook Islands is a self-governed jurisdiction under free association with New Zealand. And as such, it has a very stable, well-regulated, safety-conscious legal framework. We also utilize NEVIS as another jurisdiction. Now, there are multiple safety barriers in place to protect client assets and ensure the integrity of the financial services industry as well. Statute of limitations. Why trust age is important. The age of the trust is important. There are statutes of limitations that give trust stakeholders powerful legislative protection. That is, once the trust is established and funded, your opponent could not successfully challenge a transfer of assets into the trust if they so desired. This time frame is as little as 1 year in the Cook Islands, typically 3 to 5 years in the U.S., and 10 years in a U.S. bankruptcy court. So starting and funding the trust now means that you start the clock ticking. Moreover, in the Cook Islands and Nevis, there are significant barriers in place from the beginning. So in rare cases where the plaintiffs were able to transfer the lawsuit to that jurisdiction prior to the statute of limitations time frame, it is very difficult for a legal enemy to get the courts to view the case from his or her perspective. That is because the barrier of proof for your opponent is beyond a reasonable doubt. Now, the age of the trust starts on day one, not the day it was converted to a foreign trust. Let's say that again. The statute of limitations on fraudulent conveyance clock starts ticking the day the trust is formed. So once the requisite time has expired, accusations that you created the trust to fraudulently deprive a creditor of yours will fall on deaf ears. The courts will refuse to entertain such an accusation. What do most people want? Most people want powerful asset protection to thwart off a legal attack. You work hard for your money. So if somebody sues you, you want them to have to work much harder. People also want to maintain control. This trust gives you the virtual control from beginning to end. That is, it puts you in the driver's seat when the legal atmosphere is calm. Then when the litigious hurricane begins to stir in your life, the terms of the trust, which you yourself agreed to were in your best interest, kick in to protect you. Experience. This organization was established in 1906. We believe we have well over 65,000 clients, and it is our experience that this trust works. We know of no client of ours who has lost money with funds housed in a properly established and operated trust with the trigger mechanism in place. Trigger trust summary. The trustee/protector triggers the offshore asset protection trust mechanism when you encounter sufficient legal duress. The client can be the trustee, maintaining full control until the client needs the offshore trustee to step in and protect trust assets. The trust is not tied to a particular domestic jurisdiction. As such, the trigger trust has greater immunity from attacks in jurisdiction where case law has opened holes for legal predators. The filing of the 3520 forms, FBAR, and meeting FATCA requirements are not required prior to pulling the Foreign Asset Protection Trust trigger. The trust includes estate planning provision, so when parents die, for example, the trust can care for future generations. When children mature and encounter legal attacks, the trust can stand strong, keeping your family legacy intact. Plus, it has very reasonable ongoing fees to cover the trustee and annual government renewal filings. So if you have assets that you want to protect or have questions, give us a call at 1-661-310-2931 or visit assetprotectionplanners.com and request a free consultation. This is the Business Guy.